Welcome back to the District Court Show. This is a production of the 10th Judicial District. I'm Judge Steve Halsey from Wright County, and our guests are Chief Justice Lorie Gildea and State Court Administrator Jeff Shorba. So, Chief, if you could talk then about when a case is accepted or comes to your court on appeal, how is it discussed? When is oral arguments scheduled? Who is determined to write the opinions? That type of thing.
Yes. So your case is at our court, and the vast majority of our cases we tee up, so to speak, through an oral argument. And argument sounds like it's a mean thing, but it's not. It's not. It's just like a conversation, just similar to what we're doing now, where the lawyers come and present their arguments. So the argument date, you can really back up everything from there. So in advance of the argument, the court gets access to all the materials in the case, and oftentimes a lot has happened in the case by the time it gets to us. We'll get boxes and boxes of transcripts in front of the trial court and the jury proceedings and all the exhibits. And so we get all of that. And then the lawyers submit written arguments to us. They submit briefs, and I don't know why we call them briefs because they never are. But they submit their written arguments to us. And so all 7 of us have access to all of that information. One of the 7 of us is randomly assigned the case to really dig in and do a soup to nuts examination, figure out really what happened, and read all the cases that the lawyers bring to our attention and all the cases that are relevant that perhaps weren't brought to our attention in the briefs, and do an analysis of the case and prepare what we call a bench memorandum. And everybody on the court then gets a copy of that bench memorandum 1 week before the case is argued. And in that memo, the justice to whom the case has been randomly assigned makes a recommendation as to how the case should come out. Should we affirm or agree with the result below, or should we reverse? What should happen? So there's a recommended outcome. All 7 of us get that. We all do our own homework, and then we come onto the bench and have the conversation with the lawyers. And there's a lot of give and take with the attorneys about what the issues are, and really some testing that goes on. Justice Sam Hansen used to describe our court as a hot court, and I wasn't really sure what that meant. I think what he meant was we ask a lot of questions, and we do. It's a great conversation. It lasts about an hour. And then as soon as we're done with our oral argument calendar for the day, we usually have 2 cases, the 7 of us go back into the conference room, and we make a decision in the case that same day. And that the decision-making process starts a little bit during the oral argument. You can hear from some of the questions that the justices are asking, perhaps what they're thinking about the case or what they're troubled by in the case. And so then we go back into the conference room. It's just the 7 of us in there. And the justice to whom the case has been randomly assigned starts the discussion and summarizes the case and makes a recommendation as to how the case should come out and explains why. And then we go around the room in order. We do everything in order of seniority. Oh, okay. And we take our turn and speak about what we think. Do we agree with the recommendation or not, and why? It's a very thoughtful, deliberative process, somewhat formal. We address each other as Justice so-and-so. We don't interrupt each other. We just really listen, understanding that that's such an important part of our job. Is we're not deciding these cases alone. We have 6 others, really smart, hardworking people to draw on, and we need to listen to them, and we need to be open to being persuaded and learning from them. So we go around the room then, and the chief speaks last. And then when this formal process is over, then there's often a more free-flowing sort of tug and pull testing discussion that goes on. Do we really think this rule makes sense? Let's change the facts. And if the rule is such, does that make sense if we change the facts? At some point, it's my obligation as chief to end it, because we got to do something else, move on to the next case, and to sum up where we are. And if the justice to whom the case was assigned has a majority, which for our court is 4, the vast majority of our, well, I shouldn't say the vast majority, but most of our opinions are unanimous. We're not always unanimous. Sometimes we're even 4 to 3. I mean, pretty divided. Sometimes it happens. But if the justice to whom the case was assigned has a majority, then that justice will write the opinion for the court. If not, then I, as Chief Justice, will assign the opinion to someone else. The court makes its decisions in writing. We issue opinions and orders in our cases so that people can see what the rule is and why. So once we've reached a decision and we know who the authoring justice is, then the writing process starts. And it can take us a little bit of time we're writing, hopefully, to stand the test of time.
Does the writer then have the majority that joins with the writer review that and ask for edits?
So then what happens is, let's just say that Judge, that you were assigned to write the majority opinion. So you go back to your chambers and you work with your law clerk, who's a newly minted lawyer, who helps you craft the document, and you may go back and forth with your law clerk several times on a draft before you're ready to circulate it. But then it circulates to all the other members of the court, and everyone has the opportunity to propose edits, and sometimes can be really tedious, right, when you're getting edits from 6 other people. Right. But it's always helpful. And then everyone has to weigh in, too. There's a circulation cover sheet where we have to initial, and you have to weigh in on which side you're on, and sometimes you change your mind. I mean, we all know it's easier to say something than it is to write it down and have it really make sense. And so sometimes you change your mind in the review process, and then a case maybe it flips, and then we start the writing process over again. That doesn't happen often, but it does happen.
How about if you're in the minority side? Do you meet with the other person that's in minorities, or peer persons, and then? So
the way that works is, if we just assume again that you're writing the majority, and let's say that I'm writing the dissent, so you would work up your majority and you would send it to me, and I would write my dissent, and then I send it back to you so that you can respond to the arguments I make.
Okay.
And we go back and forth like that, literally, until we're exhausted, and we've said everything there is to say. We've gone down all the hallways and opened all the drawers and checked all the places and cubby holes, and we've said it all. Then the 2 documents circulate together to the other members of the court. So that's how that works.
It's quite a process.
It is.
That sounds
and
fascinating.
We do our best to be transparent about it among the 7 of us, because we feel strongly it's not my decision, it's not your decision, it's a decision of the Minnesota Supreme Court.
Members of the community who wish to watch, these are oftentimes presented to you by oral argument.
Yes.
Is there a means for the members of the community to watch these oral arguments, and in addition to that, to review and read through your decisions?
Yes. We do have, of course, all of our proceedings are public proceedings, and people are welcome and encouraged to come and attend and observe oral argument. Television cameras are allowed to come into our court proceedings, and so there may be news coverage. We also, on our website, have streaming of all of our oral arguments, and so you can go and watch the oral argument in a case. And we have, as part of our court calendar that comes out in advance, there's a little issue summary. We, of course, think all of our cases are fascinating. But if you're interested in coming over, or some of your viewers are interested in coming over, you can look on the website and see the issue summary, and then you can read about the case and see if it might be interesting for you to come and watch it live or look at it later on your computer.
And then every year, a couple of times, the Supreme Court goes out and hears arguments, outstate, I guess I'll call it, and we had the pleasure of having the Supreme Court in Buffalo in 2009. And interestingly enough, one of our newer judges, it was a case that she had tried as an Anoka County Assistant County Attorney, and ended up going to the Supreme Court, heard in Buffalo, and she was a trial judge there, so that was very interesting. Talk about how that process happens. Maybe, Jeff, I know your office is involved with that as well.
Yeah, the court goes out, we take our show on the road, so to speak, twice a year. We go to a high school in the metro area in the spring, and we go to a high school that's not in the metro area in the fall. And it's a great opportunity for us really to engage the larger community and let people see what we do. Courts in Minnesota don't belong to judges and lawyers, they belong to the people. And so it's critically important that we as judges and justices get out and talk with the people and let them see what we do. And these outreach visits to the high schools are just one of the many examples that the judges in the branch are engaged in terms of engaging the community.
Announcing your decisions, are they simply published for the public, or
Yes.
do you announce them such as the U.S. Supreme Court does?
We don't have that kind of reading of the opinions that the United States Supreme Court does from time to time. Our opinions are all released on our website so that people can see them that way.
And when are they released?
They are released on Wednesdays at 10 in the morning.